I'm going to introduce Professor Irving Abella, who's then going to introduce our speakers, Devin Pendis and Lawrence Douglas. Wow, I still feel like I'm competing with a lot of people out there. So come in and settle, and let's quiet down. We're going to start. So I want to introduce Professor Irving Abella. Who is the Schiff Professor of Canadian Jewish History at York University. He specializes in the history of the Jews of Canada and the Canadian labor movement. And he received his Bachelor of Arts degree, Master of Arts degree, and PhD, all from the University of Toronto. His books have included Coat of Many Colors, 2 Centuries of Jewish Life in Canada, and None Too Many, Canada and the Jews of Europe, 1933 to 1948, where we were lucky enough to host him this fall to talk about that subject at the Berkeley Institute. He is also the honoree of a number of awards. He's a member of the Order of Canada and a fellow of the Royal Society of Canada, among many other honors and awards. And I welcome him up here to introduce our 2 speakers for this afternoon. Thank you.
Thank you. Delighted to be back. And welcome to the concluding panel of this wonderful conference. The responsibility of this panel, as we were told by the irrepressible leader of this session, Rebecca Gobert, is to bring together the threads that have been woven throughout the day. The panel is entitled History, Memory, and Morality, Revisiting the Holocaust and Nuremberg through the lens of today. And our task is to build on the discussions of the previous sessions and speakers, reflect where we are today and where we are going. And our panelists have been asked to examine the legacy of Nuremberg, the trials, the developments since the trials, and to talk about what has happened over the past 70 years. And we could not have found 2 better presenters, 2 of the leading scholars in the field. Devin Pendis is an associate professor at the Department of History at Boston College, a graduate of the University of Chicago. He is the author of the Frankfurt Auschwitz Trial, Genocide, History, and the Limits of Law, as well as several forthcoming books on war crimes trials, and dozens of articles. And Lawrence Douglas is the Grossfeld Professor of Law, Jurisprudence, and Social Thought at Amherst College. He is a graduate of the Yale Law School. He's a prize-winning author of several books, including the book The Memory of Justice, and has written several novels, unusual for a historian, but I'm very proud. Several novels, one of which was shortlisted for the National Jewish Book Award. So our format is simple. Each of the panelists will speak for about 15 minutes, followed by a panel discussion, and then questions from the floor. Our first speaker, Devin.
Okay, so let me start with my heartfelt thanks to the organizers. I haven't been to Berkeley since I was a teenager, so it's a real pleasure to have the opportunity to come back here. It's always a pleasure to have the opportunity to kind of reflect on the serious political, moral, legal issues that get raised by the Nuremberg trial and its aftermath. Michael Maris earlier today mentioned some of the work I've done on what I have come to call the legalist paradigm of war. This is a phrase that I borrow from the philosopher Michael Walzer, but he used it fairly narrowly, and I want to reconfigure it in a somewhat broader way. As Michael mentioned in his talk this morning, one dimension of what I've been calling the legalist paradigm of war concerns this notion that war itself and that wartime conduct can and should be legally actionable in some way, that it's not just a political or a military issue, but that it's also a legal issue. But it also has 2 further dimensions that I think are crucial. First, the legalist paradigm of war asserts the possibility that acts of state can be criminal. This is not quite the same thing as a doctrine of state criminality that was heavily debated after World War II, but you don't declare states per se criminal, but you declare acts of state criminal, right? And then the second dimension is that the legalist paradigm insists upon individual culpability for crimes related to the initiation or the conduct of war, and increasingly also other forms of mass political violence, civil war, insurrections, that sort of thing as well. And therefore, it maintains that the fact of state criminality, or that acts of state can be criminal, does not excuse individual actors for their culpable actions in state-sponsored crimes, right? Both of these elements, state criminality, individual culpability, have many earlier antecedents in the history of international law, and I agree completely with Michael and his comments earlier today about the kind of the late 19th century antecedents of this. But it's the conjoining of those two elements after the Second World War that I would contend marks a substantial departure from prior practice in the history of international humanitarian law and the laws of war. 2 points should be made here. First, the legalist paradigm shifted from a civil to a criminal understanding of the relationship between law and war. So if one looks, for instance, at the Hague Law, right, the Hague Conventions, it held states responsible for violations and foresaw reparations as the proper remedy. Geneva law did envision criminal prosecutions for violations, but only by the states who were party themselves. So if your soldiers committed a war crime, it was your state's responsibility to prosecute them, right? So there was no international jurisdiction under earlier Geneva law. Both of those things change in 45, right? So you start to see that criminal sanctions should be applied to all violations, and that international jurisdiction should be available for all of these acts. And that, I would suggest, marks a pretty substantial departure with what had been typical practice prior to that. Now, what I'm calling the legalist paradigm of war encompasses all of the usual typologies of international law pertaining to armed conflict, the laws of war properly speaking, international humanitarian law. One thing that I would just mention in passing here that's important is with the passage of the additional Protocol 2 of the Geneva Conventions in 1979, I believe, the kind of all of this gets brought much more tightly together, and civil conflicts and insurrections also get incorporated. So, somebody asked earlier today a question about ISIS and stuff. Post-Protocol 2 to the Geneva Conventions, I think what happens is that non-state actors are incorporated into the existing laws of war paradigm, and so become actionable on the same terms as state actors, right? Today I want to ask how we should understand the role of particularly the International Military Tribunal at Nuremberg in the emergence of this legalist paradigm, and to interrogate then towards the end its relationship to the more or less contemporaneous emergence of human rights as a distinct international legal project, but also as a distinct international political project. There is a controversy among international lawyers addressing particularly that latter issue, the question about the relationship between international humanitarian law and international human rights law. I'm not going to get into that debate particularly. It's a lawyer's debate. It concerns various and sundry kinds of questions of doctrine. What I want to interrogate, because I'm not a lawyer, I'm a historian, is actually the politics and the political implications of the legalist paradigm on the one hand, and of the emergence of human rights as both a legal and political language on the other hand. Right? My argument is that while the legalist paradigm of war and human rights, or if you want, you can call it the human rights paradigm of politics, share certain kinds of normative impulses and share a certain commitment to legalism, their political logics are rather distinct and in some ways perhaps even divergent, right? Whatever their specific legal relationship between international humanitarian law and international human rights law. And I want to suggest that this, partial divergence of humanitarian law and human rights has as one of its points of origin in the Nuremberg trial. All right. So let me start with the political logic of the legalist paradigm of war before then turning to the political logic of human rights. As I said, this legalist paradigm seeks to encompass both state and individual criminality, and in this respect marks a departure from key aspects of the traditional laws of war. But why? Right? Why make this move to link these two dimensions of criminality? Part of the answer, I would suggest here, lies in the fact that the legalist paradigm originated in a moment of what I would call founding uncertainty. Right? The interlinked sets of programs to legally prosecute Axis criminality in the aftermath of the Second World War in both Europe and Asia had many multiple points of origin. Right? This is a vast global project that operates at many, many different levels. Right? At the apex, obviously, were the two international military tribunals in Nuremberg and Tokyo, but there were also a myriad of national trial programs by the victorious Allies, by formerly occupied countries in Europe and Asia, and even by some of the defeated powers themselves, most notably Germany and Austria, and tellingly not Japan. These various diverse powers that are initiating trial programs after World War II all had different distinct agendas, different political problems they were wrestling with, different legacies of criminality that they were wrestling with. And it's really only in the complex mixture of all of these dimensions that this legalist paradigm emerges. And so, one way you could interpret this is to say, well, there's no real paradigm there at all. What you've got is you've got a hodgepodge and a mishmash. I think at the level of programs, that's true. And I've, written to that effect that I think that there's not one project of trying Axis criminality, but out of these different projects emerges something like a logic that I, have suggested constitutes a paradigm. Now, let me try and be a little concrete here, right? The International Military Tribunal at Nuremberg is crucial, not just because it's the theme of today's conference, although that's certainly useful, right? But because it concentrates many of the different factors involved in the emergence of the legalist paradigm. It's not for nothing that in the late 1940s, the International Law Commission of the United Nations or the International Law Commission was tasked by the United Nations with formalizing the so-called Nuremberg Principles as a first step towards enacting a new international criminal code. And the reason that the International Military Tribunal and the Nuremberg Principles became the touchstone, I think, for this project of developing international criminal law broadly, international humanitarian law more specifically, is that because it was the product of four-power negotiations, right, it already embodied the compromises that were necessary for anything to happen in the aftermath of the Second World War. Out of this kind of morass, if you will, of conflicting agendas emerged a foundational uncertainty that gets to the heart of the Nuremberg Project and its legacy. Was the goal to humanize war, or was it to criminalize it? Right? The governments in exile that initially pushed for the criminal prosecution of Nazi crimes, many prominent civil society activists, and Raphael Lemkin, who's been mentioned here as the founder of kind of the concept of genocide, would be the kind of the poster child for this, right? As well as no small number of statesmen, especially among the British and the French, right, thought that the focus should be on Axis atrocities after the war. In other words, war crimes and what would come to be called crimes against humanity should really be the focal point of post-war legal activity. This view held that it was the excessive violence against civilians that had made World War II so horrific and that required a legal remedy. Others, right, including U.S. Secretary of War Henry Stimson, Robert H. Jackson, who formed the focal point of the film last night, more ambivalently, President Franklin Roosevelt argued that it was Nazi aggressive war that itself was the root of evil. If there had been no war, they argued, there would have been no war crimes. And I think that's certainly true, although it's notable, and it's been mentioned here before and also in much of the literature, that this, of course, downplays the specificity of Nazi genocide of the Jews, right? But the kind of the core assumption is that the war itself is the foundational crime, right? The second project, that of, therefore, of criminalizing aggressive war, was by far the more radical of these two projects, right? Criminalizing atrocities, I would suggest, is less daring and less utopian as a project than criminalizing war itself, right? The core idea of the attempt to criminalize aggressive war was to replicate at the international level the pacification of civil conflict that had accompanied the consolidation of the modern state in the early modern period in Europe. Right? In principle, the international community would lay claim to that monopoly of legitimate force that Max Weber had identified as the core function of the modern state. This would then replicate on a global level the civilizing process that Norbert Elias had argued characterized Euro-American modernity since the Middle Ages. Now, we can bracket here the one-sidedness of this understanding of modernity, but the notion is that we're going to do at a global level, at an international level, what the state had done at a domestic level, and we're going to, pacify the world by reining in who can operate legitimate force and restricting it to one actor, in this case, the international community. There is obviously a great deal of idealism, indeed utopianism, embedded in this project of criminalizing aggressive war. But most of the men, and they were largely men, who advocated it, like Stimson and Jackson, were not starry-eyed idealists. They were statesmen and politicians. They envisioned this as a going concern in the real world. For this vision, then, to be at all plausible, right, in the real world, the criminalization of aggressive war necessarily had to be connected to the creation of an effective mechanism for collective security, right? Otherwise, it would be a dead letter, a utopian gesture in the void. And this is where it gets connected up with the founding of the United Nations, right? In this respect, it makes sense, as the historian Elizabeth Borgward has shown, to think of Nuremberg and the founding of the United Nations as being sort of twins, right? And both as being part of an attempt to construct a new multilateral world in the aftermath of the Second World War, a project in which the Americans were centrally involved, but certainly were not the only ones, right? In this respect, the effort to criminalize aggressive war also marked a merger of what Mark Mazower has argued were two opposed traditions in U.S. thinking about international governance, a kind of legalist tradition that supported mediation and an international court of justice, think Teddy Roosevelt, and a collective security tradition that supported international institutions and alliances, think here Woodrow Wilson, right? Now, the likelihood of this project of collective security and criminalization of aggressive war coming to fruition after the war may be doubted from its inception. Certainly, at a minimum, what I would say is that it had to depend, if it was going to actually work in the world, on the emergence of some kind of U.S.-Soviet co-dominion in the post-war period. Right? Here, Francine Hirsch at Wisconsin has done a lot of work on the Soviets in Nuremberg. It's significant that the idea of prosecuting crimes against peace initially came from the Soviets. Right? The Soviets were the first ones to propose this. Certainly, FDR toyed pretty seriously with the idea of creating a durable post-war alliance with the Soviets during the latter half of the war. There was a lot of opposition to this within his administration, to be sure, right? Particularly from the career diplomats in the State Department who were all vigorous anti-communists. It's also not clear how serious the Soviets were about engaging in this project, right? It certainly seems doubtful that they were willing to engage in kind of a shared hegemony with the Americans on terms the Americans would be willing to accept. Right? And we see this in the breakdown why there's not a second international military tribunal after the first, which was supposed to prosecute monopoly capitalists in Germany. Right? In the event, it doesn't really matter. Roosevelt died before the war ended, and his successor, Harry Truman, was much more skeptical of any post-war cooperation with the Soviets, even before the State Department kind of was able to influence his thinking on this. Right? Certainly by the time of that the IMT started in November of 1945, a month after the UN Charter, the prospects, I think, for permanent cooperation between the Americans and the Soviets were dim, to put it mildly. The UN itself emerged as a deeply ambiguous institution, attempting on the one hand to secure international cooperation and collective security, while defending the principle of sovereignty and the non-intervention of domestic affairs, and above all, while enshrining the prerogatives of the great powers in the form of the veto power of the permanent members of the UN Security Council, right? So it's really trying to serve two masters institutionally. And I think certainly in the context of the Cold War, it ended up amounting to very little, but not just the Cold War. If you see the history of the UN since 1989 and the mounting tensions again between the Americans and the Russians, I think it's a structural limitation of the United Nations at work there. Okay, so it's not surprising then that if you look at the development or the attempts to develop international criminal law, international humanitarian law after World War II, aggression becomes the key sticking point, right? In the context of the Korean War, the UN commissions the International Law Commission to come up with a working definition. They can't. By 1954, the UN calls off all work on the development of an international code because of the inability to reach consensus on a definition of aggression. It only resumes then again in the 1990s, right? And I think here one could then bring it up to the present, which is part of our job here, right? It's not at all surprising then that the negotiations for the Rome Statute, founding the International Criminal Court in 1998, could not reach a definition of aggression, right? It proved to be one of the major sticking points, and they postponed any attempt to come up with a working definition of the ICC, aggression, lest the entire ICC project have to be scuttled on that basis. It was only in 2010 that a definition of aggression could be worked out at the Kampala conference, and the court's jurisdiction over the offense won't take effect until 2017. That's assuming that 30 state parties ratify this amendment. As of March 2015, only 12 state parties had thus far ratified it, including powerhouses like Luxembourg and Denmark, right? It's also telling that you could only reach a definition of aggression after the United States, Russia, and China merely had observer status for the negotiations. Because they're not state parties to the Rome Statute, they couldn't have a vote on this, right? So you could really only even reach that definition once the three great powers were only modestly involved. It's also telling that the jurisdiction of the ICC over aggression is very different than its jurisdiction over crimes against humanity, genocide, or war crimes, right? Basically, it can have jurisdiction if a case is referred to it by the Security Council, meaning the Security Council has veto power, right? The prosecutor or state parties can initiate an investigation for aggression, but only if the prosecutor can certify that the UN Security Council has declared a certain act to be an act in violation of the UN Charter, that is to say, an act of aggression, which means, again, de facto, the Security Council has veto power over the ICC's jurisdiction over this, right? In other words, right, what we see here, the post-Nuremberg concept of linking the criminalization of aggression to the UN's collective security apparatus remains firmly intact, which in this instance means that it also remains almost wholly unworkable. Right? It's hard to imagine that there will be very many cases where there is sufficient consensus among the permanent members of the Security Council for the ICC to secure jurisdiction over aggression. And if this ever does happen, it will almost certainly exacerbate the already notable trend in ICC indictments, which is that only small, diplomatically isolated, third world, mainly African countries get indicted or investigated, right? Basically, it's what I call the Air Force rule, right? Countries with air forces don't get indicted by the ICC. As a consequence of the difficulties confronting the radical project of criminalizing war, humanizing it, which had originally been the subordinate project at Nuremberg, emerged as the only viable option left. Right? Already at the successor trials, there was a departure from criminalizing aggression and a shift to what Lawrence Douglas has termed and will term here in a few minutes, right? The atrocity paradigm of international criminal law, right? The point of this, which, basically criminalizes certain kinds of wartime behavior, certain kinds of excessive casualties against non-combatant populations, right, recognizes the unavoidability of military violence and merely seeks to ameliorate its worst effects. In so doing, this atrocity paradigm validates to a meaningful degree existing power relations. States can use force without question, right? The fact remains that international humanitarian law protects the rights of the powerful to coerce the less powerful. Right? One sees this above all in the ways in which the crucial concept in the laws of war, international humanitarian law, is the doctrine of proportionality, which holds that violence may be used, including violence against non-combatants, as long as it is proportional to military necessity. Right? What this does is it recognizes that sovereign violence is a legitimate activity. Right? For all the talk of ending impunity for war crimes, the history of the International Criminal Court confirms the suspicion that this is primarily true for those who either lose wars or who lack sufficient international backing to be protected by the UN. Right? Okay, now the final question I want to turn to is what this has to do then with human rights, right? Because that's the other major development kind of in terms of global moral politics and law, international law after 1945. And there's two trends. There's a trend of partial convergence and a trend of partial divergence. I mean, the most obvious convergence between the legalist paradigm and the emergence of human rights is a commitment to legalism, right? Human rights are, in fact, a robust, broad political language that manifests in many diverse civil society contexts, and I think that's actually where their true power lies, right? But in practice, right, human rights activism has remained strongly committed to the language of law, international law in particular. Much of the activism around human rights focuses either on the crafting or implementing of international legislation. The UN system of monitoring and reporting on human rights violations is strongly linked to international law. The language of gross human rights violations, which permeates the discourse of both UN agencies and civil society monitoring groups like Human Rights Watch or Amnesty International, is ineluctably legal in its character. Right? This legalism, I think, helps to explain in part the second dimension of convergence with the legalist paradigm, which is the way that human rights, like the legalist paradigm, have both come to focus increasingly on the right not to be murdered by your own government or somebody else's. Right? The originally very capacious vision of human rights articulated in the Universal Declaration, embedded in particularly the Covenant on Social and Economic Rights, has largely narrowed in terms of the public attention. These documents are still on the books, but they have not really had the kind of robust life that the more atrocity-focused dimensions of human rights have. This is an argument that's been made by both Samuel Moyn and Stephen Hopgood that increasingly human rights has focused on genocide prevention as its core mission. Right? Now, this legalism of human rights has something to do with this kind of increased emphasis on atrocity prevention as the core of human rights. It makes sense. Mass murder is clearly a crime. Poverty is a lot more complex. Even political oppression, censorship can, depending on circumstances, fit uneasily into a legal frame. For instance, think about blasphemy laws, right? So this shared legalism of international humanitarian law, international human rights law, the legalist paradigm in human rights politics, both in effect have de-radicalized these two projects. Right, have rendered them less utopian, more perhaps realistic, but much narrower in their scope. Right? Now, the last point I would say, though, is there is a point of divergence between human rights and the legalist paradigm, right? Which is that The legalist paradigm is, as I've argued, necessarily linked to questions of the power of the sovereign state, right? Even as the legalist paradigm seeks to protect individuals from the depredations of states, their own or others, it reaffirms the rights of states to violence and to determine substantially the proper exercise of that violence. Right? International human rights, by contrast, seek to articulate rights held mainly individually these days, but to some degree also collectively, independent of the state, right? I mean, some of these rights are, of course, held against states, right? But others might envision the state as an agent for their fulfillment, some kinds of economic rights, for instance. But in either case, the logic of human rights does not depend for their functionality on reaffirming the rights of states to act in the way that the legalist paradigm ends up doing. Again, I think, the reductive legalism of much recent human rights talk may mitigate this to some extent, but the core logic of human rights remains ontological, not sovereign. And by this I mean you have human rights by virtue of your status of being a human being, independent of your relationship to any given state. They're not citizenship rights. Right? And that's very different, right? They are implicitly rights that one might have in an imaginary world in which there was no such thing as the state, right? That's very, very different, right? So in that respect, then, this is an area where human rights law and human rights logic politically diverges from the way that the legalist paradigm has developed since Nuremberg, right? The acceptance of violence implicit in the legalist paradigm of war is rather different than the utopianism of human rights as a vision of rights unconnected from the real world in which states exist. Whether one or the other has a greater likelihood of actualization in the real world, I think, is an open question. I think both of them face very serious challenges, but I do think that we should be careful not to equate the legalist paradigm and the human rights paradigm, although we should also be aware of the ways in which both of them amount to a kind of a step back from the more radical utopian visions of a more peaceful, prosperous world that were first articulated in the aftermath of the Second World War. All right, thanks.
Thank you, Devin. Lawrence?
I think I'll stand. So again, I want to begin by thanking the organizers for the terrific day. I've never actually been at a conference with quite this format with tables here. It feels a little bit like a cabaret. I feel like I should be like singing New York, New York or something like that to you all. It's been a long day. My comments are going to be about a little over 20 minutes, so I think I'll leave enough time for question and answer. And in fact, I think we'd be happy to answer even questions that you weren't able to ask to the earlier panels today. We'll answer all the questions. So 50 years ago, at the time of the famous Frankfurt Auschwitz trial, which Devin has written a terrific book about, Fritz Bauer, the German Jewish Attorney General of Hessen, he expressed this simple hope that, and this is a quote, "Sooner or later, one of the accused would step forward and say, 'What took place, it was horrific, I'm sorry.' Then the entire world would exhale, as would all the survivors of those killed at Auschwitz, and the air would be cleared." Sadly, Bauer observed, it has not been uttered, nor will it be. The refusal of perpetrators to own up to their guilt, I think, remains one of the most disappointing aspects of Holocaust trials. For example, John Demjanjuk, about whom I'm actually presently writing, he was convicted in a Munich court in 2011, and notwithstanding the importance of that conviction, he remained defiantly silent through his 18-month trial, never so much as breathing a word of acknowledgement or of remorse. I suppose, though, that Fritz Bauer can now exhale at least partially. Last Tuesday, as many of you know, on April 21st, on the opening day of his trial in Lüneburg, where he stands accused of complicity in the murder of 300,000 Jews during his service at Auschwitz, the 93-year-old Oskar Grönig faced the court and acknowledged, and this is a quote, "It is beyond question that I am morally complicit. This moral guilt I acknowledge here before the victims with great regret and humility," end quote. It was, I think, a very important moment. But in acknowledging his moral complicity, Grönig actually fell short of confessing his legal guilt. And indeed, for years, he's insisted in his innocence as a matter of law. So, for example, in 2005, in an interview with the German news weekly Der Spiegel, he said, and this is again a quote, that he had been no more than a cog in the gears. And at Auschwitz, what his responsibility was, he was responsible for inspecting the luggage of deportees to the camp, most of whom would be gassed within hours of their arrival. And he was responsible for examining this luggage for banknotes, which would then be carefully counted and sent to Berlin. And in performing this task, Grönig insists that he never engaged in cruel, murderous, or sadistic acts. And I think we can probably accept him at face value when he makes that statement. And instead, today, I actually want to focus on his claim that being a cog did not constitute a crime, because I think that claim brings us to the heart of, in particular, Germany's troubled history of bringing perpetrators and accomplices of the Holocaust to justice. And the problems that Germany confronted in ways are paradigmatic of larger problems. In fact, I think you could say that confronting the destruction of the European Jews through the criminal law severely tested traditional conceptions of law and jurisprudence. There must be some law students here. The law typically views the criminal acts microscopically, that is in the standard model which law students study. It construes crimes as deviant acts that are committed by individuals, typically against other individuals, and these deviant acts harm norms of community order. Different legal systems, of course, reach different conclusions about which specific acts constitute such a threat, but all legal codes condemn foundational wrongs, the most basic of which is murder, and instruct the nation state to respond aggressively, mobilizing its judicial resources to the end of apprehending, prosecuting, and ultimately punishing perpetrators. And if we go back to the great text of Leviathan by Thomas Hobbes, which I would say is arguably the greatest work in Western political thought, there we encounter the notion that the state is more than simply the bulwark of order. It is the very force that protects us from the violence of strangers. Nazi crimes exploded this model and its assumption that private violence represented the most basic threat to the fabric of social life. For Nazism revealed the terrible capacity of the state itself, of the state to turn reprobate. And this is a phenomenon that the German philosopher Karl Jaspers designated with the term Verbrecherstaat, which means criminal state. And Jaspers' term illuminated how Nazism turned the state into the principal perpetrator of crimes, that is, the very agent of criminality. And in his opening address at Nuremberg, we've spoken about a lot, and we saw in films of Justice Jackson yesterday, Jackson framed the legal challenge that was posed by the Verbrecherstaat, and he said the following. He said, civilization asks, again, civilization as this critical term in the rhetoric of his opening presentation, civilization asks whether law is so laggard as to be utterly helpless to deal with crimes of this magnitude by criminals of this order of importance. The Nuremberg trial and those that followed insisted that law was adequate to the task, but that the effort would require extraordinary legal innovations. Now, some of these legal innovations we've already spoken about this morning. So mastering the crimes of the Verbrecherstaat would require, first and foremost, new categories of wrongdoing. That is, categories that would have to be sufficiently flexible and sufficiently capacious to handle crimes which spanned a continent, which enlisted the participations of tens of thousands of perpetrators, and were supported by a complex organizational and logistical apparatus. So what were these incriminations? Well, again, we've spoken about it this morning. They are crimes against humanity and genocide. We've already noted that Nuremberg conferred for the first time judicial recognition on crimes against humanity, which was the term that it used for state-sponsored atrocity. And the prosecution used this novel legal challenge to bring much of the evidence of the Holocaust before the IMT, before the Nuremberg Tribunal. And we can talk again about how perfect the Nuremberg was at recognizing the crimes of the Holocaust, but nonetheless, they were importantly brought before the tribunal at Nuremberg through this legal channel. And genocide, of course, is the term that we also mentioned, was coined by Raphael Lemkin in 1944, originally designed to describe the Nazis' treatment of Jews in occupied territories. And as we saw, Lemkin's coinage was meant to describe something distinct from mass murder, and indeed something more grave, that is, in his language, a coordinated destruction of essential foundations of the life of groups with the aim of annihilating the groups themselves, end quote. But in addition to these new incriminations, the effort to punish Nazi atrocity also gave rise to new jurisdictional principles capable of puncturing the shield of sovereignty that has traditionally insulated state actions from outside legal scrutiny. It stimulated the development of specialized investigatory units. For example, the Office of Special Investigations in the U.S. Justice Department, another body called the Central Office for the Investigation of Nazi Crimes in Germany. And these were special dedicated offices that really kind of revolutionized the role that professional historians would play in the preparation of criminal cases. And it kind of returns us a bit to something that we talked about this morning, which was the fact that this professor of Columbia, Salo Baron, he testified at the Eichmann trial. Well, if you actually fast forward and look at some of these other trials involving against Holocaust perpetrators and accomplices, there you find historians not simply kind of providing background material to the prosecution in order to establish a context, but you actually find them working closely with lawyers for the purposes of making the case, basically preparing the case itself. The contact with the Holocaust also led jurists to experiment with flexible rules of evidence, equipped to facilitate rather than frustrate the prosecution of state-sponsored crimes. This sometimes took the form, for example, of relaxing the application of norms of hearsay, which would ordinarily be applied in Anglo-American trials. These were relaxed for the purposes of trying, again, to have kind of a more capacious legal process that could deal with these crimes. And it also sparked, of course, the creation of special courts, some of them international, like at Nuremberg, some of them domestic, and some of them as of a hybrid character that we've also spoken about this morning. And I think this is something that Michael Basler said this morning as well, that in certain respects you could even make a claim, not hyperbolically, that the law's attempts to grapple with the legacy of Nazi mass atrocity has really, in a way, given birth to the field that we now refer to as international criminal law. But not all legal systems embraced what I've called the atrocity paradigm, as Devin warned that I would. And I suppose there's also kind of a sort of professional hazard of professors using the word paradigm to characterize their own little thought about things about things. But this atrocity paradigm, again, all I mean by this is this notion that special law and processes were needed to respond to Nazi crimes. And most notably, Germany rejected this atrocity paradigm. It rejected the new incriminations designed to facilitate prosecuting Nazi exterminators. Now, even where these legal innovations gained acceptance, they still encountered what I would describe as another foundational problem that was raised by the phenomenon of the Verbrecherstaat, of the criminal state. In the classic model of retributive punishment that, if some of you endured reading Immanuel Kant, there you encounter the classic view that punishment functions as a just desert. That is, in this view, punishment is something the criminal, in a sense, has earned, that the purpose is not to rehabilitate, it's not to correct him, but it's really meant to restore the moral imbalance that's caused by a wrongful act. And Nazi atrocity, I think we can say, introduced a radical disequilibrium into this Kantian equation. And at the time of the Nuremberg trial, Hannah Arendt, the famous German Jewish thinker, famously observed, and this is her quote, "For these crimes, no punishment is severe enough. It may well be essential to hang Göring, but it is totally inadequate. That is, this guilt, in contrast to all criminal guilt, oversteps and shatters all legal systems." And the problem of the inadequacy of punishment was hardly a trivial matter. To the contrary, as Arendt tried to suggest, it really raised a profound jurisprudential question, because such crimes expose the limits of law as a retributive scheme. Now, in an earlier book, I tried to argue that jurists sought a way out of this dilemma by reconfiguring the basic purpose of the atrocity trial. In the process of researching the record of Holocaust trials, I was struck by the fact that numerous prosecutors defended these proceedings as didactic or as pedagogic exercises, something that we spoke about a bit again this morning. In these cases, these jurists explicitly sought to use the trial as a means of teaching history, that is, of creating narratives from which political lessons could be teased. And in calling these cases didactic trials, I intended no criticism. And in fact, this again goes back to something we spoke about this morning. A question was raised about whether these kind of didactic trials are inevitably show trials. And in fact, I tried to distinguish these exercises from the show trials that were kind of in vogue in the Soviet Union under Stalin. And my deeper argument was far from being an incidental feature of such trials, that the didactic aspect the didactic aspect represented a juristic solution to a juristic problem. That is, if Nazi atrocity revealed the limits of the conventional criminal trial as a retributive exercise, then the didactic trial delivered an expanded justification for prosecuting. So even as the atrocity trial would, of course, try to perform the conventional legal function of ascertaining the guilt of the accused and of assigning punishment, it would simultaneously also serve to teach history and history lessons. And I believe, as we heard again this morning by Hannah, that the Eichmann trial probably stands as the greatest success of this exercise in didactic legality. Now, by contrast, John Demjanjuk, who I mentioned at the outset, who was condemned in Munich in 2011, well, many of you probably know that he was also tried in Israel in the late 1980s. And this was the so-called Ivan the Terrible trial that took place in Jerusalem starting in 87 and in 88. And that trial represented, I would say, the collapse of the didactic paradigm. In one of the most notorious cases of mistaken identity in the annals of law, Demjanjuk, who was a Ukrainian-born SS collaborator who lived for many years, as many of you no doubt know, in suburban Cleveland, Demjanjuk was convicted as this notorious guard at Treblinka, this guard known as Ivan the Terrible, only to have his conviction tossed out by the Israeli Supreme Court once the Israelis discovered they had the wrong Ivan. And it turned out that Demjanjuk had been a death camp guard, but not the evil Ivan the Terrible of Treblinka, but more of the kind of Ivan the Not-So-Hot of Sobibor. And the causes of this disastrous case of misidentification, they are in fact really quite complex. But the calamitous trial, I think, made abundantly clear the perils of didactic legality. That is, it showed how the desire to confer honor on the lived memory of survivors of atrocity trials and to trust at face value their capacity to engage in accurate identifications years after the fact can lead a criminal's trial badly astray. The Demjanjuk's Munich trial, by contrast, represented an emphatic break with the Holocaust trial organized around survivor testimony, that is, such as at the Eichmann trial, and it also represented an emphatic break with long-standing German case law. Now, politically and culturally, Germany, I think, we can agree, is kind of almost the poster boy of national self-reckoning. It's the country that's really quite willing to face down its monstrous past. It's fair to say that Germany has approached the collective task known as Vergangenheitsbewältigung, confronting the past, with a kind of Teutonic thoroughness. It's made past atrocities the subject of countless memorials, symposia, film, and other public discussions. But when it came to bringing Nazi perpetrators to the bar of justice, the post-war German legal system amassed a really rather pitiful record. And most crucially, as I mentioned before, Germany rejected this atrocity paradigm. Again, the idea that special law and special institutions were necessary to do justice to Nazi crimes. And instead, Germany insisted on treating Nazi atrocities as ordinary crimes to be treated by ordinary courts applying ordinary German law. And among European nations, Germany alone insisted that among European nations, Germany alone insisted that trying Nazis for crimes against humanity or for genocide would represent an impermissible, indeed an unconstitutional violation of the bar against retroactivity. And we don't need to go into great detail right now, though if you have questions about this, I'd be happy to answer them, about how German jurists arrived at what I will describe as a disastrous conclusion. But as a practical matter, it meant that the very incriminations that were designed to facilitate the prosecution of Nazi exterminators, again, crimes against humanity and genocide, that these incriminations were for German prosecutors, they were just off the table. They couldn't use them for the purposes of their post-war prosecutions. Well, this raised, of course, a thorny problem. And the problem is what charges could be brought against former Nazis in Germany. And given the posture of post-war German jurists, of course, only an incrimination that was in place during the Third Reich could survive a challenge based on retroactive application. So, theoretically speaking, German jurists might have concluded that even the worst Nazi atrocities violated no law in place at the time. But that result would have been, to use the technical legal term, crazy. It would have meant that no one involved in Nazi extermination could have been prosecuted in post-war Germany for anything, because however atrocious the actions, they didn't constitute crimes under law that was operative at the time. Now, fortunately, German jurists concluded that they were not powerless. After all, murder obviously had been a crime that was on the books in the Third Reich. People had been prosecuted for normal murder and convicted of murder during the Nazi era. So it was reasoned that this statute, the ordinary murder statute, could be used for post-war trials. And this seems straightforward enough, and yet it was not. Because as one leading German expert has noted, quote, in the Third Reich, the will of the Führer was recognized as a source of law. So by this logic, it was kind of absurd to claim that in ordering and approving acts of extermination, Hitler made himself a criminal under German law because he was the source of that law. So this expert insists that it's therefore, quote, historically false and juridically a fiction to believe that the legal standards of damals, of back then, could supply a proper ground for these post-war prosecutions. And yet this juridical fiction was exactly what supplied the basis for these German prosecutions of Nazi criminals. And the consequences of that approach were really quite far-reaching, both as a conceptual matter and as a practical matter. As a conceptual matter, this meant that all Nazi crimes, acts of extermination, acts of genocide, would be treated as ordinary crimes, no different from an ordinary conventional act of murder, except perhaps in its scope, in the numbers. As a practical matter, the need to pigeonhole Nazi atrocity into the German law of murder created gross complications. And at its most basic, I'm not going to go into great detail about this right now, but at the most basic, the German law required evidence of an Einzeltat, that is, a personal act of killing. And prosecutors needed to show that in order to convict someone, even as an accessory to murder. By this standard, mere service as a concentration camp guard, again, in the absence of any evidence of any kind of specific act of hands-on killing, mere service as a concentration guard did not then constitute any crime whatsoever that could be prosecuted. And as a consequence of that, there were many members of the Einsatzgruppen, these mobile extermination units or guards at death camps, who simply never faced trial at all in post-war Germany. John Demjanjuk's conviction in Munich in 2011 marked a historic break with that jurisprudence. The prosecution in Munich faced, again, precisely the problem that had disabled many of these earlier cases, that they had no evidence whatsoever that Demjanjuk had killed with his own hand. That is, they had very clear evidence that he had served as a guard, but they had no evidence whatsoever about his specific conduct or actions while serving as a guard there. But the prosecution got around what had been an insuperable obstacle to convicting in earlier cases by developing a rather brilliant and simple theory. And it was a theory that was specifically tailored to the realities of service at a death camp. And the argument was almost kind of structured as a logical syllogism. That is, it ran something like this. All Sobibor guards participated in the killing process. Demjanjuk was a Sobibor guard. Therefore, Demjanjuk participated in the killing process. And the reasoning was deductive, so even if in the absence of specific evidence that Demjanjuk had personally engaged in an act of killing, it had to be the case that he aided and abetted murder. So while still nominally treating the Holocaust as an ordinary crime, the Munich court managed to shatter the old paradigm and comprehend the Holocaust as a crime of atrocity. And again, if you're interested in how that kind of theory was developed, I'd be happy to go into greater depth about that. It is perhaps ironic, though, that a man whom Israeli prosecutors mistakenly pursued because of his alleged singular cruelty and viciousness ultimately was convicted in Munich as a mere functional entity, a replaceable cog in an exterminatory machine. Yet the court rightly, in my mind, it rightly recognized that a machine cannot run without its small constituent pieces. That is, Demjanjuk was properly convicted not because he committed wanton murders or because he was some kind of SS sadist. He was convicted because he worked in a factory of death. He was convicted of being an accessory to murder for a simple and irresistible reason, because that had been his job. And this returns us to the comment that we looked at the very outset, which was Oskar Grönig's statement and his insistence that he was no more than a cog in the gears. But now I think we can see that by the standard framed in the Demjanjuk verdict, Grönig's claim that he was no more of a cog, that is now an admission of guilt. And this doesn't mean that Grönig deserves the same measure of punishment as some kind of SS sociopath. In fact, it's not entirely clear to me what punishment he deserves besides the symbolic gesture of conviction. But without the court's conviction, in my mind, Grönig's important acceptance of moral guilt will remain incomplete. Grönig's trial is significant for reasons other than building on the Demjanjuk precedent, however. Of course, our conference today coincides with the 70th anniversary of the Nuremberg trial, but it also coincides with an anniversary of a different sort. As many of you probably know, this past Friday, on April 24th, marked the day that millions mourned the killing of hundreds of thousands of Armenians by the Ottomans during the First World War, an event, of course, that many, though not all, have described as genocide. And yet, of course, the Turkish nation itself remains in denial of the mass killings that unfolded 100 years ago. And with that in mind, I think that Grönig's trial reminds us of other mass atrocities that still await their moment of moral and legal reckoning. So thank you very much.
Thank you. Thank you, Lawrence. The papers today have been terrific, and we've learned much from them, and they raise all sorts of questions. But taking the prerogative of a moderator, I will ask the first one. It's a question I've wanted to ask for some time at conferences on Nuremberg and war crimes trials. It's a question that's out of the box, but with two experts, two moralists and legal theoreticians, I thought I'd have a go at it. It's important 70 years after the Nuremberg trials to recall and reaffirm the legacy of the trials, that the Nazis almost succeeded, not only because of the pathology of hate and the technology of terror, but as Elie Wiesel reminds us, because of the crime of indifference. According to Wiesel, Nuremberg is a story not only of those who did the killing, those who committed the crimes, but also of those who did nothing. The killers killed, the victims perished, and others stood by, his famous words. Today, governments sit idly by as criminal states are once more back in style. 200,000 people murdered, butchered in Syria, hundreds of thousands, perhaps millions in the Sudan and the Congo. Red lines are crossed. Boko Haram, ISIS continue murders, and there are no consequences. So, my question, would you say that indifference to genocide, to mass murder is acting as an accomplice? That governments have learned nothing from Nuremberg? We recently, we talk about paradigms and doctrines, but the world seemed to have adopted, at least in part, the idea of responsibility to protect. And they used that excuse in Libya, and the Russians misused it in the Ukraine, but we've forgotten it. So my question to both of you is, what happened? How come 70 years later we seem to have forgotten these lessons and have resorted back to the days before 1939?
I'm happy. Do you want to go or?
No, go.
I mean,
Give me a minute to think about that.
I would start off by saying no. I don't think that the crime of indifference. I don't think indifference rises to the level of a crime. And this might be a controversial position to stake out, but I do think this term that we often bandy about, this notion of humanitarian intervention. It seems to be the case, you see some kind of unfolding human rights tragedy or atrocity someplace in a far-flung part of the globe, and you think, oh my God, that's an absolutely horrible thing, and isn't it absolutely heinous, the fact that you have the states that kind of stand by and watch what happens, and isn't there some kind of moral or even legal imperative that we intervene? But I think that humanitarian intervention is an incredibly fraught issue, And what often looks like a humanitarian intervention can very easily bleed into something like imperialistic intervention in the affairs of another state. And it can become a pretext for all sorts of meddling in the internal affairs of another country. And even when you do engage, and let's talk about something that's the closest, and this actually goes a lot about what you were talking about with human rights law and international and with the law of armed conflict. I mean, probably the closest war that we've engaged in on human rights is on a strictly what we might consider as a benign intervention was the air war over Kosovo and Serbia. And if you are going to engage in some kind of humanitarian war, which again, I would say has a certain kind of oxymoronic ring to it, but if you are going to engage in that type of intervention, it is unmistakably the case that the popularity of that type of intervention is going to be very, very low domestically. It is extremely hard to sell humanitarian intervention domestically. It's much easier to sell it when you're able to say that your national security interests are directly at stake and therefore demand intervention. Well, see, it's a case in point. And so if you look at something like the air war over Kosovo, in order to maintain domestic support, we basically had our jets that engaged in this air war flying at a very high ceiling so they couldn't be shot down. As a result of that, because we knew that as soon as we started absorbing casualties, the war would be over, because the domestic support would end like that. And so as a result of that, you have far more civilian casualties on the ground, because we engaged, at least at that time, in high-altitude bombing that was far less precise. So, and this is that collateral damage when we're now intervening for the purpose of trying to mitigate or stop some kind of human rights abuses abroad. I would say it's an exceptionally fraught and difficult issue, and I would just caution against what might seem like the natural idealistic response, which is, of course, we have some kind of moral obligation to intervene for the purposes of putting an end to human rights abuses. I think it's an exceptionally difficult thing to do.
Yeah, I mean, I agree with almost everything that Lawrence said. I mean, what I would add is, I mean, this was the problem the UN was supposed to be able to solve in the first place, right? Because most of the problems that you're identifying stem from the fact that the intervening agents necessarily are going to be themselves states, right? Who are, very often not completely neutral in these conflicts, or, and it's very hard for them to maintain, at least a full appearance of neutrality. So the Russian perspective on our intervention in Kosovo was very different than the American perspective on this, right? And they saw this very much as an act of American expansionism into areas of their traditional sphere of influence, et cetera, right? So it's very, so in addition to the issues that you raised about, killing civilians to save civilians, there's the issue that one person's humanitarian intervention is another person's war of imperial expansion. The UN and collective security mechanisms were intended to provide a venue in which collective action would be possible in response to these sorts of crises, right, whether wars of aggression or humanitarian crises, but could only, in order to secure its existence, could only be done in such a way that made it impossible for it to actually do the job it was intended to do, right? And so I think that we've recognized the problem. I don't think we've come up with a solution to the problem, right? And I'm not sure that a solution to the problem is really possible, at least not until such time as there's some, hypothetical world in which you could actually replicate the functions of a state on an international level, world government, or whatever you want to call it. And I think that's something that is, beyond a pipe dream at the moment. And, until the Martians land and teach us, better ways, I don't anticipate that coming about anytime soon. And so I think we're just kind of in an ineluctable dilemma in this. Because the final point I would make is, I also agree that I don't think non-intervention or standing by, certainly at the national level with these kinds of things, constitutes a crime. But I do think that it raises very serious moral problems, right? I mean, I do think that this kind of notion of being a bystander in the face of mass atrocity is not trivial from a moral point of view. And even if you don't have a legal obligation, and even if it doesn't make sense to impose a legal obligation to intervene, and even if it's morally fraught to do so, I think not intervening is not without moral price.
Terrific. We have to wait for the Martians to land. We have 15 minutes for questions. Wait for the microphone, please.
This question was provoked by the prior panel. My question is, in terms of creating an historical record and teaching the community in real time, the world community, about an event and serving the interests of the victims' families, how have the Truth and Reconciliation Commissions performed in comparison to these criminal trials?
Well, one thing I would say is that I don't think you necessarily have to think of it as an either or. Like, it's not necessarily either you have a criminal trial or you have a Truth and Reconciliation Commission. I think, again, a lot of these things have to deal with, sometimes they can complement one another. Certainly, you could have, you could imagine trials. I mean, in fact, you find this kind of thing that countries that first embraced the notion of some kind of Truth and Reconciliation Commission, very often they did that because they were, in a sense, there was no other alternative to do so. And then you find them actually now wanting to have some type of criminal trial reckoning with the past as well. So I would, first of all, say that the two can complement each other. The other thing, in terms of like which is a better tool for the purposes of teaching history or clarifying the historical record, again, it's one of these things where I don't think you really necessarily want to say one is better than the other. I think they each have strengths, and I think they each have weaknesses as well. That is, I think it would also be somewhat facile to suggest, and I'm not saying you're suggesting this at all, but I think sometimes people come along and they say that, oh, well, these criminal trials, they're incredibly clumsy tools for the purposes of trying to establish a baseline account of history, and it's much better to have this kind of flexible, elastic tool like a Truth and Reconciliation Commission, and I actually just don't buy that. I don't think that's actually accurate. I think very often criminal trials, in fact, one of the things is that they do have this kind of unusual capacity to galvanize international attention. And I think that capacity to galvanize international attention is a tremendous advantage that trials have over, let's say, certain kinds of Truth and Reconciliation Commissions. At the same time, Truth and Reconciliation Commissions, they don't necessarily have to kind of pigeonhole history through some of the evidentiary conventions that govern criminal trials, even though I've also tried to suggest that in these trials you do find courts actually experimenting with unusual evidentiary conventions, especially so that crimes of atrocity can be brought before a court in a more interesting, less constrained fashion. So I guess my own answer to the question is that I don't really see one as kind of enjoying an advantage over the other, and I actually think that it's often the best when the two work in tandem with one another. Maybe the final thing, if you don't mind me just saying, is that I think it also depends, it's a little bit hard, you don't really want to get involved in one of these these exercises of comparing like whose atrocity is worse than whose, but I think it does turn a little bit about the facts on the ground. I mean, if you're having a state that is transitioning or trying to transition to democracy, and it's the actual state that was, in a sense, inherited its own authoritarian past, like something like South Africa, it might be an incredibly destabilizing thing to try to launch an aggressive and ambitious trial program. Whereas if you're talking about something like a genocidal episode of genocide, like with the Holocaust, then it seems very hard to talk about just some kind of reconciliation in the absence of using the arm of the criminal law. So I think sometimes the facts on the ground also affect the choice.
Yeah, I mean, again, I find myself in more or less complete agreement. The one thing I would add is that while I think Lawrence is quite right that this atrocity paradigm was in part an attempt to deal with the problem of retribution for crimes that escape retribution, for many survivor victims, but also for no small number of third-party former bystanders, retribution remains actually a really central part of what they hope to see out of these processes. And so, no small number of survivors have, expressed some, substantial frustration with Truth and Reconciliation processes over these. I mean, I think about the fact that Stephen Biko's widow in South Africa, for instance, launched a lawsuit that went to the South African Supreme Court in an attempt to stop the Truth and Reconciliation Commission in South Africa from going into effect because it came with an amnesty attached to it, right? So for at least some survivors, this notion that you would have truth without justice, truth without retribution of some sort was pretty unsatisfying for them. And I can understand that, right? I mean, the notion that somebody's going to get up there and say, yeah, you know what? I tortured lots of people to death and I'm a really bad person. And now I'm going to go retire to my little villa up in the hills and, raise grapes, is frustrating, right? So I can totally see that.
This is a question for Professor Douglas. You made an important, I think, from your perspective, point about if one is a cog in a machine, there's not only moral responsibility, but a legal responsibility. And certainly, and my question is, where does that take us in terms of individual responsibility in our lives in general and in any kind of hostilities in particular? For example, we can look at from the perspective of our own history and our own country, but also others. We can look at, say, the atomic bomb, that was dropped on Hiroshima and Nagasaki. What responsibility do the pilots have, the people that put the bomb on the plane, the people that developed the bomb? Similarly, what kind of responsibility individual soldiers might have, say, that fought in the Iraq War and were cogs in a machine? What responsibility do the Saudi pilots have that they are bombing Yemen, even though their own country is not, it's not really self-defense? And I wonder whether you could comment on those kinds of issues.
Yeah, it's an excellent question. I mean, it's an excellent question also in the sense that it's directly the question that these German jurists had to struggle with when they were, because as I was mentioning, this Demjanjuk case represented a pretty important departure from German case law. And in accepting that, in having this willingness to depart from the case law, they basically had to answer the question that you're asking, which is, where does this cog in the machine argument end? That is, how far do the cogs, is it the case that if you're preparing the sandwiches for the people who are going to be the SS guards, who are the ones who are responsible, are they then kind of accomplices as well? And the answer that the court gave there, which I think it largely resonates with my own feelings, is that if you are reducing guilt to function, which I think is a critical thing to do when you're dealing with genocide, that itself seems to be a very important and difficult jurisprudential move to begin with. Again, it kind of abandons the typical criminal law model of responsibility. So once you start kind of thinking about guilt as function, it seems like you want to kind of limit that or tie it as closely to the criminal process itself. That is, one of the questions arose really directly with Demjanjuk was, let's say someone was just a dedicated cook, a cook for the SS. Would that be someone who was close enough to was he a cog in the machine? And at least my feeling would be no. That you really needed someone who would be a little closer, someone who is escorting people from the trains to the gas chambers, people who are doing like what Grönig is doing, which is he's right there at the ramps at Auschwitz. He's going through the luggage. He knows another train's coming. He's ordering people to get the luggage off the train to facilitate directly the next group of people to be killed. And so it does strike me that at the same time that that I think it's crucial to have this capacious notion of guilt following function, I still think you need to kind of tie it pretty closely to events that are directly part of that killing process. Now again, we can talk about this. There are these, I haven't mentioned this, there are these very elaborate theories that have been developed at these international courts about the Yugoslavia Tribunal, about these notions of joint criminal enterprise, and we can kind of talk about that. But that's my view, at least, is to try to tie it pretty closely to the logic of the criminal enterprise.
Wait for the microphone, please.
We've gone through a full day of conference and hardly discussed this at all. That relates to the American government's failure to recognize the International Criminal Court of Justice. My question is this: do you two panelists both condone the American position in failing to participate, in failing to fund the International Criminal Court of Justice? And would you not agree it's a terribly relevant question to discuss in the context of Nuremberg of 70 years ago?
Yeah, I mean, the American government hasn't really been waiting for me to condone much of anything that it's done over the last 20 years, but fair enough as a question. I mean, I think that it is very telling right, that the United States, Russia, and China are all not state parties to the ICC statute, right? I think that it highlights the ways in which the project of using criminal law to either criminalize or humanize warfare is closely linked to efforts to construct a more stable, peaceful, cooperative international order more generally. And the reason that the Americans are not party to the state, to the ICC statute, the reason that the Russians, the reason that the Chinese are not, is that they want to preserve freedom and room for maneuver in international politics, the ability to launch preemptive invasions of other countries, without fear of sanction. And, in a world in which that level of international cooperation remains absent, I think we can expect that the International Criminal, that the International Criminal Court is going to have a hard time attracting active support from people who are likely to invade other countries, basically, is what it comes down to. Now, do I condone this? No. And I would also like it better if my country was less prone to invading other countries, right? But in terms of what I think is likely to happen, right? I mean, I think that's where we're at. Now, again, I think it's a little bit, you have to be careful not to be naive about what the International Criminal Court could achieve either, right? In the absence of a really effective collective security mechanism on a global level, we are in a situation in which states will use violence to defend their perceived interests. And we don't necessarily want to say that that's always wrong, even if it is often wrong. And so I think that that's where politics really comes in, and we need robust, political processes, both domestically and internationally, to kind of call attention to improper wars, to call attention to wars that are fought in ways that exceed reasonable boundaries, right? And the ICC can be an instrument for that, but it can also be, I think, a hindrance to that. Again, I think the ways in which the ICC is we came up in one of the earlier panels. I think there's a very grave risk that the ICC is well along the path of completely delegitimating itself in the eyes of much global opinion because of its focus on a very specific subset of crimes that, in the eyes of many, are not the crimes that are really egregious in the world. And I'll be very curious to see where the ICC is at in, say, 10 years in terms of the level of international support that it gets. I know with some alarm that Canada, in part for domestic political reasons, in part for international reasons, has largely turned its back on the ICC, even though it was one of the major state sponsors of it initially in the Rome Statute, right? So do I condone it? No. But do I think that it's something that is a very real part of the world and not likely to change anytime soon? Yes.
Yeah, if I can just respond to that a bit also. I don't think it's exclusively the case that just because the United States wants to reserve the right to invade other countries. I do think, this goes something that Devin said a little bit earlier. I think it's a little easier for a country like Finland or Luxembourg to sign on to something like the ICC because Finland and Luxembourg is not the police of they don't basically police the entire world, which is the way the United States does, for better or worse. And, I do think so. There are some legitimate concerns that the United States would have that countries that have, or places in the world that have a problem with U.S. foreign policy would try to settle political scores through the arm of the criminal law. That said, I do think that the American response, particularly under the Bush administration, as you probably know, Clinton on his last day, they sign on to the Rome Treaty, and then we basically get the whiteout and we kind of remove the signature, which is the first time that's ever happened in American history. And then it would actually be misleading to say that under Bush we didn't participate. That is, the Bush administration actually tried to do everything under its power to subvert the fledgling court. The spirit under Obama has actually been a spirit of cooperation. So we've actually moved very far away from what our attitude was during the Bush administration. But so I look forward to the day when the United States does become a signatory. The one final thing I'll say about the ICC, though, and this connects to something that Devin said, and also connects, I guess, back to Nuremberg, is that, as Devin pointed out, right now, there's only a prospective jurisdiction over the crime of aggressive war, that there was this definition that was arrived at in Africa, in Kampala, in the summer of 2010. But in my own mind, I think it would be a mistake to bring aggressive war back into the quiver of international prosecutors. I think it would be much better to focus on what I've described as these crimes of atrocity, these war crimes, genocide, and crimes against humanity, because I think there's basically no way to avoid the politicization of law once you start using aggressive war again as one of the linchpins of prosecution.
In the back, please.
I wanted to follow up on another aspect of the cog in the machine argument, and also take you up on your offer to answer questions from this morning. Because this morning we heard about the Kharkov trial and the young lieutenant who pleaded guilty to a crime under duress. And I'm wondering how that argument has played out. I mean, first of all, he said he would have been murdered by a German tribunal if he resisted complying with orders. Is that true? But assuming it is true, or for the sake of argument, I'm sure we can find other cases in the world where it is true. How has that played out in the intervening years?
Do you want me to go for it? Yeah. Well, it was a kind of a fascinating thing that came up in this Demjanjuk trial in 2011, because again, there were two basic questions that they had to answer. Is that, was this guy an accessory to murder? And if so, did he serve voluntarily? Now, one of the things that made the Demjanjuk case particularly fraught with regard to the second question was that, recall that Demjanjuk, he was not a German. He was not a Nazi. He, in fact, was a Ukrainian who was in the Soviet Red Army and taken as a prisoner of war. And so then the question was, can you speak about voluntary service, about people who were originally prisoners of war and then were basically impressed into service by the SS? He was trained by the SS. And again, kind of a lot of kind of go back to something I was mentioning, is that we really had nothing to go on except what historians could make aggregate statements about people in a situation like Demjanjuk. And one of the things that they basically were able to argue is again, that when it came to general questions of SS guards, there's never been a single instance, not one, in which an SS guard who opted out of genocide ever faced peril of life or limb. Now, it is the case that in many trials that Devin knows intimately well as well, that defense of duress was exceptionally, that German courts were exceptionally receptive to that defense of duress, but became much less so once that historical knowledge actually came out that, in fact, these people were not faced with draconian punishment. In fact, basically, was opting out of genocide a smart move? No. Was it like, if you wanted to make yourself a big career in the SS, would it help you out? No. Would you be branded a wimp? Yes. Would you be branded a Jew lover? Yes. Is it possible that they would say, look, if you don't like this cushy guard service at a death camp, you can go to the front and fight with the other SS, other like soldiers. So it wasn't necessarily a comfortable choice, but it certainly was a choice. And the critical thing in a defense of duress or necessity, the argument is you had no choice. And it's one thing to say that one's choice is abrogated or somewhat limited, and it's a very different thing of saying that there is no choice whatsoever. And I think in times of war, very often people are confronted with difficult choices. I don't necessarily want to position myself, or I can't necessarily answer with any kind of confidence how I would have behaved. But again, these are choices that people had to make, and it seems fair to hold them responsible for the choices that they did make.
Can I just, one other thing is, especially in the German context, there was another defense that was, especially in the 50s, quite successful, which is putative duress. So you weren't really under threat, but you had reasonable grounds to think you were under threat, even though the threat wasn't actually real. And so, it turns out nobody was executed by the SS for refusing to kill Jews, but I thought that was what would happen to me. And it was not unreasonable of me to think that. Therefore, I acted as if I were under duress, even though it turns out I actually wasn't, but I didn't know that. And that was a defense, again, that especially in the 50s was pretty successful in German courts until historical research revealed that, the refusal to participate was not that rare, right? I mean, there was a fair number of SS men and German soldiers and stuff who did decline to participate in mass murder. And so the people who did participate would have seen these other guys not participate and would have seen that nothing particularly bad happened to them. And so their claim that they, wrongly thought that they were under duress falls apart then, because if you've seen three guys say, you know what, I'm not going to shoot kids in the back of the head, sorry, and nothing bad happens to them, you can't say, well, I thought if I didn't shoot kids in the back of the head, they were going to shoot me. That argument sort of falls apart too. So that's, again, one of these areas where, just the development of historical knowledge really shifts the kind of the terrain of what's going to work and not work as a legal argument.
It's also, can I tell you one other little story about the Demjanjuk thing? Do you want to hear? Well, one of the things that was interesting is Demjanjuk, for his defense wasn't that resourceful, because one of the problems that they did is his first line of defense was, I was never there. So he continued to deny that he ever served at Sobibor. And if you think about the logic of what Devin was just describing, this necessity defense or this putative necessity defense, it is a defense. That is, it is a recognition that, yes, I was there, but I had no choice in the matter. It's very hard to make that kind of argument the way Demjanjuk, given the profile of his defense. It's hard to say something like, I was never there, but if I had been there, I would have been coerced to be there. So it was very hard for him to make that argument, even though he tried to make it. And the fact of the matter is, if he had actually come forward and said, look, I'm not a particularly brave person, but I'm not a coward either. And I was, the first day I was there, I saw another one of these former Soviet prisoners of war taken out. He had tried to flee from the camp, and he was shot in my face, shot right in front of my eyes, and I was very scared as a result of that. Now, he might have been lying through his teeth, but the fact of the matter is there was absolutely no evidence whatsoever about what he did there. And so that would have actually arguably made some complications for the prosecution, but he actually never made that argument.
Final question, Michael?
Thank you. I just can't let the question about Kharkov go without mentioning what I thought, Michael, you were going to at least mention, so let me do it now. The principal argument against such trials in the course of the war was the reciprocity argument. That is, once the Soviets started to try German war criminals, the assumption would be that the Germans would try Soviet war criminals. The unusual thing was that the Germans were murdering Soviets by the hundreds of thousands anyway, and so they didn't need to worry about, the Soviets didn't need to worry about the reciprocity argument. Well, anyway, we could follow that up, but I want to get into my question here, which I think in a way reflects on the entire conference. I've watched everyone listening with such rapt attention to the papers and to the questions afterwards. One of the things that I think is so compelling about the subject that you have chosen and that we've discussed for a whole day is that this is the territory of dilemmas. There are no easy answers here. And we've had two terrific papers in this panel. They're very dense, and it's difficult to bite off a piece on which a question can be answered, but I want to ask a historian's question of Devin Pendas now, because I think it reflects one of the dilemmas. Devin, it has to do with the double focus of what became the international humanitarian law community, namely abolishing war or abolishing aggressive war on the one hand as an objective, and on the other hand, humanizing war. And these two elements are constantly interacting, let me now say. It's not just at the end of the Second World War or around the time of Nuremberg. This goes back to the 19th century. Lieber, Dunant, they were interested, if you like, in humanizing war. in making war less atrocious, less destructive. But against this view, there was another view, namely abolishing war. And the latter was very strong. It was behind the Hague Conference of 1899 and 1907, which were known as the Hague Peace Conferences. As that debate rolled out, in a nutshell, the people who opposed the idea of humanizing war said, all this will do is to make wars longer, to draw them out, to make wars more common. You humanize it, well, war doesn't have the same disincentive. The idea is to make war as atrocious as possible. Murder the greatest number of people because that will bring the speediest end to war. This is essentially what Clausewitz said. And he had some, let's say, more humane associates who argued similarly. Now, what is interesting, I think, is the way this debate between these two parties sort of rolls out. If you like, before the First World War, the humanizing of war people, I think, had the strongest voice. But in the interwar period, as a matter of fact, I think, the outlawing of war through institutions, in this case it was the League of Nations, this had the strongest voice. And then things shift again with the United Nations and Nuremberg. And at Nuremberg, the American case, which was made so strongly, was that aggressive war is the right way to go. So, Devin, I'd like to ask you how you reflect now on these dilemmas. We've gone back and forth. Each one has its upside. Each one has its downside. And if I might say, I think the whole idea that there are easy solutions to these great human wrongs is a mistake because, as Lawrence, you pointed out, immediately when you open up a quick solution to some atrocity situation, you end up with the sort of dilemma that you talk about. Well, yes, you can do that. We might all feel better. But on the other hand, we might make things worse, and we might end up with more people killed. Right?
Well, if I gave the impression that I thought there were easy answers to this, I apologize, because I certainly don't think that there are any easy answers in this arena whatsoever. I think you're quite right that in the interwar period, the notion that one might be able to criminalize war and the Kellogg-Briand Pact, sort of actionable as it was a step in that direction. This is, of course, linked to the fact that in the aftermath of World War I, there was a very rare moment, I think, in world history in which pacifism was actually a really powerful and viable political force in world affairs, right? It's one of the only times I can think of where that it is, in fact, true, right? And yeah, well, it came to be known in the 30s, absolutely, right? And it's not, George Lansbury, the chairman of the British Labour Party in the 1920s, was a out and out pacifist, right? One of the few times the leader of a major political party close to government in any country I'm aware of was just flat out saying, I'm a pacifist. We will never go to war under any circumstances. It's a terrible thing. I think that what I find interesting about the post-World War II moment, and it's a very short-lived moment, is that this is there's a kind of a dual project of both outlawing and humanizing war. That's the Nuremberg moment, and it comes really close to the centers of world power in a way that even I would suggest, Kellogg-Briand has, an exit ramp that you can drive a Mack truck down, right? And so, the idea in Nuremberg and the idea in the International Law Commission was to really shut down the off-ramp, right? And to really criminalize aggressive war in a much more robust kind of way. And that went nowhere. And I think the dilemma is that, in a way, it can, it's part of what you said, Lawrence, but it's also related to the dilemma that pacifism more generally faces. If you think about what George Orwell said about British pacifists during World War II, said, there are times when you have to take sides, and if you choose not to take sides, you're taking sides with the other side. Right? And so being a pacifist in the Second World War objectively means, giving aid and comfort to the Nazis. And that's a very problematic position to be in. And I think that you can end up in that situation where, you have a humanitarian impulse that produces, bad outcomes. And again, I think, in a world in which you could actually have something like an international state that could make authoritative, declarations and legislate in a fair and legitimate way to regulate conflicts, you can ameliorate this. I mean, medieval Europe looked a lot like international society looks today, with a lot of warring parties with their own sovereign authority. The emergence of the modern state did manage to tame this. I mean, this is not just a sociological just so story. But I see no indication whatsoever that anything like that is happening on the international stage today. And if you look at the problems that the EU is having right now, I think that there's reason to think that even regional agglomerations that have tried to move in that direction on a regional basis are not always having smooth sailing, right? So I don't think the notion that we're going to, move in the direction of a set of regional federations on a step towards world government, which lots of people in the late 1940s were arguing. Wendell Willkie leaps to mind, right? The 1940 Republican presidential nominee. I don't see too many people who would make that argument today. And so I think this is a dilemma that's just not going anywhere.
Rebecca, do we have more time?
No more questions. If Lawrence wanted to respond, will you?
Yeah, I mean, the only thing, it was more directed to, the only thing I might mention, and it doesn't actually go directly to, I think, Michael's question, but since you were talking about the intersections between law of armed conflict and human rights law, they really are kind of, I think very often, I think this is one of the points that you're making, but I think people tend to think of them as complementing each other, and I think the idea is that they're very much on a collision course in a lot of ways. The law of armed conflict, the most basic proposition is when you talk about someone being a privileged combatant, people think about, what's the privilege of the combatant? Does that mean that they have to be treated as a prisoner of war, that they have to the Geneva Conventions kick? The privilege that combatants enjoy is the privilege of killing. That is what they're allowed to do. The law of armed conflict authorizes killing, and human rights law does not authorize killing. And at the most basic, even though these bodies of law have often worked together, in many ways they're on a collision course. The other thing that I would mention also about, at least my understanding of the law of armed conflict, is a lot of that was generated out of a model of this kind of nation states warring, in which you have these tanks lined up on a frontier fighting each other, and it's meant to regulate the conduct of war in a kind of classic World War II model. And you try to apply that to, we had a question about ISIS earlier, you try to apply that to the asymmetric warfare of today, and that model becomes almost distorted to unintelligibility. So I think a lot of the dilemmas that we're facing today are real challenges to the basic model that had developed in the Nuremberg, out of Nuremberg. So.
Well, this is probably an appropriate place to end, talking about armed conflict and tanks. And I'd like to thank our two panelists for a terrific session, and on your behalf, I'd like to express our appreciation.